Good afternoon, everyone. Welcome to the Sipc Modernization Task Force public hearing. My name is Sharon Bowen. I am co-chair of the task force. I am also vice chairman of Sipc and a partner at the law firm Latham & Watkins. I am joined today by some of my fellow members of the task force: Joseph Borg, director of the Alabama Securities Commission; Stephen Caruso, an attorney with Maddox, Hogarth, Caruso, a law firm which represents public investors; John Coffey, the Adolph Burrow Professor of Law, Columbia University Law School; and James Giddens, Lehman Brothers trustee and an attorney with Hughes, Hubbard & Reed. We are here in our individual capacities as members of the task force and not on behalf of our respective organizations or Sipc. The task force was formed in 2010 to do a comprehensive study of the Sipc statute and Sipc's operations and policies. Our mission is to make recommendations to the Sipc board on ways to modernize the Sipc statute in order to further Sipc's goal of customer protection. The task force met for the first time on June 16, 2010, and since that time, there have been many more meetings, either by phone or in person, to discuss concerns relating to Sipc. The task force will complete its initial work this month and then draft its report. The report will contain the task force recommendations, which we expect to present to the Sipc board in the fall. The report will be made public. This forum is an opportunity for the task force to hear directly from you and any concerns that you may have about Sipc and the protection it offers. We're grateful to each of you for taking the time to join us today. This meeting is being streamlined live over the web and over a telephone conference line. Only those present here today will be able to speak. For those who aren't able to be here in person, the task force encourages you to voice any concerns that you have in writing. You can do so on the task force website at www.sipcmodernization.org. This meeting is being recorded. The audio will also be available on the task force website. A written transcript of the meeting will also be made available on the website within the next few days. Because this is our chance to hear from you, we will not be taking any questions today. We will, however, listen closely to your comments and report back to the entire task force your concerns and comments. Again, thank you for joining us. With that, we can begin.
Hi. I'll just call people's names as in the order that they've signed up. Next speaker is Norma Hill.
Ladies and gentlemen, members of the forum, I have come here today to listen and better educate myself and other investors on the purpose of Sipc. Over the past 2.5 years, I have had many discussions with several brokers and financial advisors, and much to my consternation, I have found that very few of them have more than a cursory knowledge of what Sipc is all about. They, like the people that they advise in making financial decisions, lack good, sound information. Most of them, like us, believe it is an insurance that protects you against situations such as Bernard Madoff. It would seem to me that an educational program should be put into place for the industry. In fact, during my research, I found very few ever knew the background of how SIPA came into being. Investors have been accused of not doing due diligence. I find this quite extraordinary when the professionals are so lacking in information. I would hope that this has put into effect I hope that this was put into the effect for the benefit of investors and not only solely for the convenience of Wall Street. Congress passed the Securities Investor Protection Act, SIPA, in 1970 to assure that the legitimate expectations of investors were honored. The cornerstone of SIPA was the creation of Sipc to fund insurance for the customer's net equity, defined to mean the amount the brokers owed the customer. Until the Madoff case, Sipc paid insurance based upon the customer's most recent brokerage statement, including, obviously, all appreciation in the customer's account over however many years the customer had an account with the broker. In 1970, Senator Edward S. Muskie proclaimed in urging the prompt enactment of SIPA, after this bill is enacted, no American will lose his savings through a brokerage firm bankruptcy. This is not happening in the case of the 85% of the Madoff victims. When SIPA was enacted and brokers were able to buy securities in street name, American investor has nothing but the statement from their broker to rely on for the balance or the value of their accounts. Every trade confirmation that is sent to every investor of a Sipc member falsely assures them that their life savings are protected up to $500,000 by the Sipc. The American investor now knows that Sipc's promise of protection is not what Congress intended it to be. Instead, Irving Picard has created new keywords like net winner, net loser, and has redefined the congressional intent of the meaning of net equity, all in an effort to save Sipc money. An SEC OIG report from 2000 gave the following background of the Securities Investment Protection Act, SIPA. The Securities Investor Protection Act of 1970, 15 U.S.C. Section 78AAAET.SEQ, as amended, the Act, was created to protect customers from losses resulting from broker-dealer failure, thereby promoting investors' confidence in the securities market. As interpreted, the Act protects customers whose securities were misappropriated, never purchased, or stolen. SIPA defines net equity as the value of cash or securities in a customer's account as of the filing date, less any money owed to the firm by the customer, plus any indebtedness the customer has paid back. Irving Picard defines it differently, without the proper congressional approval to change the Sipc statute. In a letter dated May 1st, 2009, Klein and Wexler wrote to SEC Chairperson Mary Shapiro and said, "It is imperative that the victims of the Madoff Ponzi scheme are provided clear information and are compensated to the full extent of the law." They continue to say, Josephine Wang, the general counsel of Sipc, indicated that if investors believed that they owned securities in the investment statements they were provided by Madoff, then Sipc has an obligation to buy securities to make the investor whole. However, Irving H. Picard, the trustee appointed by the bankruptcy court of the Southern District of New York to oversee the liquidation of the Bernard Madoff Investment Security, LSC, has described a different obligation owed by Sipc to the victims of the Madoff fraud. We believe the victims of the Madoff Ponzi scheme should be compensated to the maximum extent by the Sipc. The amount of compensation provided by Sipc to Madoff victims should be based on the final statement of the securities received by customers in November 2008 up to in the amount of $500,000 per account. Congressman Scott Garrett recently introduced legislation to protect Madoff investors. Garrett said, customers of registered brokers regulated by the SEC are legally entitled to rely on their customer statement as evidence of what their broker owes them. This does not change when a broker engages in fraud. Indeed, it is there to protect customers in the event of fraud. Congresswoman Ileana Ros-Lehtinen also realizes the need to pay customers based on their last statement. She created the Ponzi Victims Bill of Rights. She said that Americans have a right to rely upon the statements they received from SEC-regulated broker-dealers. Congress, the legislative body that created Sipc, is speaking out on behalf of the victims and against the non-statutory actions of Irving Picard. We implore this task force to listen. In the New Times Securities Service, Inc., SIPA defines net equity as the amount that the broker would have owed a customer had it liquidated all the customer's holdings on the date SIPC filed for a protective decree, less any outstanding debt the customer owed to the broker. In a New York Times Steelbook article, Stephen Harbeck and Irving Picard state that they want to be fair and equitable in the treatment of Madoff investors. However, Congress did not intend for Sipc and its trustees to decide what is fair and equitable. Nowhere in SIPA does it state that a trustee for an insolvent broker-dealer should exercise his own judgment as to what is fair and equitable in paying customers Sipc insurance. Sipc's president, Stephen Harbeck, assured the New Times Bankruptcy Court that customers would receive securities up to $500,000, including the appreciation in their accounts. As Mr. Harbeck explained, if customers are led to believe that real existing securities had been purchased for their accounts, then those customers are entitled to get the full value of their securities position as of the filing date, even if the securities have never been purchased. The manner in which Mr. Irving Picard is handling net equity for Madoff victims is totally inconsistent with Sipc's 40-year history, with the original congressional intent, and with the current members of Congress. Because of his refusal to comply with SIPA's mandate that he promptly satisfy customers' claims based on the statutory balances, the trustee has decided that he needs a vast team of forensic accountants to pore through the decades of records to determine each customer's net investment before Sipc pays any amount to a customer. Clearly, this is inconsistent with the statutory scheme and the legislative intent. Customers' security positions are readily ascertainable from the November 30th, 2008 statements. In conclusion, if the trustee is allowed to arbitrarily modify the intent of the SIPA, then I am concerned for all investors because there will be more fraudulent brokers and more investors who lose their savings without the protection promised by Sipc. These investors are left to hang in the wind. Congressman Garrett said it best. If the current law is not followed, No customer can ever have confidence in his or her dealings with a broker. This is contrary to the policy goal of encouraging investment, which is critical to the economic renewal and growth that our country needs. Thank you.
Next speaker is Ron Stein.
Thank you for giving me the opportunity to speak before the Sipc Modernization Task Force today. My name is Ron Stein. I am both a financial professional and the president of NIAP, the Network for Investor Action and Protection. NIAP is a not-for-profit organization of more than 1,200 members that seeks to enhance protections for all investors, especially advocating for real reform of Sipc. While the very few minutes available today only allow me to address a few points, the most fundamental question from Sipc's perspective must be this: what can be done to best protect investors, especially small ones, and enhance investor confidence in the financial markets, consistent with Congress's original intent? Today marks the first Modernization Task Force forum since last September. While we are pleased that this additional forum is being included, we are deeply concerned that the process to date has lacked the adequate transparency, objectivity, and representation necessary to improve investor confidence. It serves under Sipc, the organization it ostensibly seeks to modernize. It lacks sufficient input from consumer groups. And despite the talent here today, it is populated significantly by Sipc and industry insiders. As a result, the recommendations of this group will be met by skepticism from the onset, most unfortunately. Turning now to Sipc itself, Sipc purports to be the first line of defense when a brokerage firm fails, and we wholeheartedly endorse this objective. Unfortunately, this is not the perception or the reality. The current industry-oriented composition of the Sipc board, the extraordinary lack of transparency of Sipc, the long record of underfunding, the history of sparing no expense and denying claims lead many NIAP members to feel that Sipc is not honoring its congressional mandate. The people I talk to every day believe that Sipc instead acts to limit its exposure and that it has put its own solvency and minimization of fees charged to the broker-dealer community ahead of investor protection. And financial professionals with whom I regularly speak feel that Sipc has reneged on its promise of protection and put yet another black mark on an industry that is struggling so hard to rebuild investor confidence. Clearly for Sipc, the Securities Investor Protection Corporation, to be viewed plausibly going forward, it must radically change its defensive and insular culture and finally view its decisions, first and foremost, through the lens of investor protection. Most importantly, the most valid recommendations by this group for the future will mean little if Sipc is not pressed to honor its commitments in the present. As long as Sipc continues to change the rules midstream to reduce or deny protections altogether for a majority of Madoff customers, or worse, from its clawback of the innocent to suit its purposes, little that this group puts forward, however well-intentioned, will be seen as valid. Now, please allow me just to take another minute to mention some of the several reforms that we are going to propose. I also would like to point out that numerous members of NIAP have declined attending today because of fear of retribution by the trustee. Let me get to some of the recommendations very quickly. First, to enhance confidence in the markets and eliminate confusion, Sipc should conform its policy with that of FINRA that net equity for the non-complicit is based on what is reflected on statements. Never should innocent victims or investors be subject to avoidance actions by a trustee, and underwriting and risk management by FINRA, the SEC, and yes, if necessary, Sipc should be improved to ferret out fraudsters and minimize risk to the fund. Second, Sipc should increase protection levels for $500,000 to $1.5 million for cash and securities, or to a level that recognizes the 30 years of inflation since its dollar limits were set in 1978. Third, Sipc should increase its fund to accommodate insolvencies of much larger impact, multiple insolvencies. The financial crisis has taught us that Sipc must be prepared to pay victims' advances well in excess of the current funding limits. Fourth, Sipc should seek to dramatically increase its transparency of its operations, increase investment consumer members on its board and staff, encourage the SEC or other agency oversight, and be required to testify before Congress on an annual or frequent basis. Accountability is of paramount importance. Fifth, Sipc should not be considered strictly as a standalone entity, but as part of a broader investor protection apparatus that includes the SEC and FINRA and works closely and collaboratively with its partners. Sixth, Sipc should embrace a more objective method of trustee appointments. Finally, investor education should be seen as a top priority and substantially expanded to help minimize further victimization of innocent investors. We at NIAP look forward to engaging with Sipc in a more meaningful conversation about the future of the agency and how to best protect the investing public. These are but a few of the suggested changes NIAP will be putting forth, and I want to thank you for the opportunity to speak before you today.
The next speaker is Leah Larson.
Good afternoon, and thank you for inviting us here to speak with you today. I'm a Madoff victim whose claim was denied because I didn't have a separate account. I had monies that were transferred directly to Bernard Madoff. I have bank check receipts to prove that the money was given to him. I never took any money out. I deposited money in 2007 and 2008, but I've been found not to qualify for any money of any sort because my money went into my brother's account, which is something that Madoff encouraged, and the money that I put in was credited to him under the net winner, net loser scheme. When Madoff first confessed, my brother called Sipc the next day, and he was told by a Sipc lawyer that we didn't have to worry, that we would receive whatever was due us based on our last account statement. So we had heard that Sipc was very difficult about paying people, but we thought that we had been told that we didn't have to worry. At the same time, Josephine Wang gave an interview with a journalist and told him the same thing. So we were shocked when on January 6th, suddenly Stephen Harbeck was testifying that none of this applied, that there was going to be a totally different scheme for payment or non-payment. Now, one thing I'd like to say, Sipc, we were told, had an incredible record of denying claims. They're only paying about 19% of the Madoff victims, but that figure is not, doesn't only have to do with Madoff victims. This is their tendency, this is their record. They consistently pay a very few small number of people the entire amount and then deny everybody else. Essentially, they're the worst kind of insurance company that one could imagine. And the way that they do it is they claim that because SIPA is a remedial statute, it has to be narrowly construed. So they go into court, and with each case, they find some way to deny people money. In our case, they're claiming that there were multiple transactions. Therefore, it's not the same as what occurred in the New Times case. Now, I was somebody who went and looked at the New Times case right after the testimony with regard to the sudden new way of figuring what people were entitled to. And what I found is that in that case, the Second Circuit found that ratified the fact that people who had fictitious investments in real securities were entitled to everything that was on their account statement, and that it was only the people who had fictitious investments in fictitious securities who didn't receive it. So I called up Sipc, and I got lucky. I spoke to Mr. Harbeck, because it's a very small organization, and when I said I wanted to discuss the New Times case, I was told everybody else was in court, and I spoke to him directly. And he said to me, well, that was about cash in, cash out. That was about the difference between cash and securities. And I said, no, that's not the part of the case that interests me. The part of the case that interests me is all the people who didn't have to appeal because they got everything. And Mr. Harbeck said to me that was because, in that case, there were no withdrawals. Now, the New Times case involved a 17-year Ponzi scheme on the part of a broker. And it had a lot of retirees investing in it. And I found it difficult to believe that nobody in all those years ever did any withdrawals. So I went to court, and I went out to Suffolk County, and I actually requisitioned the actual file in the New Times case to see what happened. It turned out that the only records there were with regard to people who did object, and some of those people did make withdrawals. The other thing that I found was a statement that everybody has been using that Mr. Harbeck made before the bankruptcy court explaining how the Sipc case was different from a regular bankruptcy case because the particular bankruptcy judge wasn't used to a Sipc case. And he specifically said that people would get their securities even if the money was stolen. We have transcripts that say that. I provided it to people. So Sipc suddenly decide that because they don't want to pay people, they're entitled to change the law is disgusting. But it's something that they've been doing for years. It's not an accident that for 19 years, Sipc only assessed all of big firms and small firms $150 a year to provide their insurance. It's because they're so good at denying claims. They go into court and they lie about the law, essentially. And that's why we need independently named trustees, people who are not beholden to Sipc, who will actually do what they're supposed to do under the law and protect people rather than trying to keep the assessments to their members at a minimum. It is disgusting that Goldman Sachs paid $150 a year to say that every one of their clients had up to $500,000 worth of insurance. And the way that this has been accomplished has been by distorting and cheating the law. And I know that because the next thing that I did is I started looking through Irving Picard's old cases and requisitioning other files. And what I found was time after time they used misrepresentation of the law to get the results that they wanted. You know, it's like if somebody doesn't start protecting people who have given up their rights to have stock certificates for the convenience of Wall Street so that they can make billions of dollars more so that they can trade more easily, which is what the whole purpose behind SIPA was, then there's no reason for people to invest if Sipc is going to continue to get away with this disgusting behavior, as noted by Gretchen Morgenson in a New York Times article in 2001, and nothing has changed. And as long as Sipc controls the purse strings, they're going to be doing people in, whether it has to do with fraudulent, unauthorized transactions, whether it has to do with Ponzi schemes, and there are plenty of Ponzi schemes all the time. There's no justification for them having such a miserable record. And one of the things that also ought to happen is that the minimum assessment with regard to Wall Street ought to be raised considerably. For them to be allowed to charge only $150 a year is disgusting. It is disgusting that Irving Picard has been able to say, oh, we couldn't give people the securities that would roil the market. The truth is there are billions of stocks that are traded every single month, And for him to start going into court and saying they couldn't give people the securities is a lie. And it's disgusting that this kind of behavior has been tolerated and glossed over by the people who are, whether it's the SEC or whatever. It's disgusting. And there's no reason for anybody to feel that any of their investments are safe under the present circumstances. And that's all I have to say.
Is there anyone else in the audience who would like to speak? We're going to take a 15-minute break. We'll reconvene at 2 o'clock. If you would like to speak, please see the registration desk outside. Thank you.
Speakers, if those of you who are here who've spoken would like to have another shot at speaking, we'll give everyone about 30 more seconds or so. Okay, welcome everyone. Thanks for coming back from the break. As you know, we had allowed it a lot more time for today, and it appears that all of our signed-up speakers have already spoken. So we decided to open the floor up if there's anyone in the room who'd like to speak who hasn't, or if there are former speakers who'd like to add more, we'd be welcome to hear any additional comments. So, not forced to, but if you'd like to. And we'll just give people a few minutes. It looks like we opened the floor, no takers. So I just want to thank you all so much again for taking the time to come today. It was really important for us to hear you and hear your voice. We will definitely report back to the full task force your concerns, your suggestions in its entirety. And as we mentioned, the transcript will also be available on the website within a few days. So thank you so much again. And obviously the website is still open for comments throughout the period. So it's not just today, but going forward as well. Correct. Yes. Thank you so much again.